Over the last few weeks, we've had an overdose of bad news coming in concerning children. The rape of the most vulnerable group of them in a Bihar shelter home, some of them disabled, so they couldn't even protest, has shaken us all. And so when the amendment to the Criminal Procedure Code, our criminal laws, was passed in Parliament this session, not even the most cussed opposition member protested too much. It came in as an ordinance in April, and this week it became a law that says death or life sentence for rapists of minors below 12. They also said life sentence for gang rape of a girl under 16, and for the rape of a girl under 16, a minimum punishment of which is up from 10 to 20 years. They also said there would be a probe in all rape cases, and all of it should be completed in just 2 months, and trial of all rape cases to be completed in 2 months. It sounds appropriate. When we hear about what happened to those 34 children who were repeatedly raped over months in that Bihar shelter, it's natural to want to kill somebody. It's natural to want quick justice, to find some punishment that would make up for the torture these children had to go through. But is this new law, which has been zealously adopted in Madhya Pradesh, which is also one of the high incidence of rape states, because is that the way? On its way to solving the child rape problem, a problem which is so grave that it means 13 rapes are reported every day, and 50% of these rape cases are against minors. We can't reality check whether the impact of that has actually brought down rape yet, because it has just been 2 months and the figures aren't in. It will take time to see that. What we are going to do a reality check on today is to look at how they are fast-tracking the cases so quickly. The most shocking case, like Nirbhaya, took 7 months to end in trial. So is it possible to charge sheet, try and punish in less than a month? We'll ask our experts. But first, here's my colleague Anurag Dwari's story from Madhya Pradesh on the new death row in the state.
In just the last 2.5 months, 8 convictions and death penalty in rape cases. This court in Madhya Pradesh's Chhatarpur awarded death sentence to a teenager for raping his 3-year-old neighbor.
In all 8 cases, the details are horrific. For example, Tauhid Shaukat sneaked into 3-year-old's house when the child's mother was talking to her brother-in-law outside. She heard her daughter's screams and rushed inside to find her bleeding. Tauhid was nabbed on the spot, beaten up and handed over to the police.
It took 31 days to file the charge sheet, 3 days to frame charges, and in a 26-day trial, 18 witnesses' testimony later, death sentence was ordered. Take another case. In Rehli area, the rapist Narayan Patel raped a child on 21st of May at a temple. He was arrested within 12 hours from a jungle near the village and charged. Investigation was completed in 72 hours, which included recording statements of 25 witnesses. 3 days later, charge sheet was filed. It took just about 10 days for the forensic report to be received, and the trial was completed in 46 days. On 7th of July, 46 days after the crime, Narayan Patel was on the death row.
सबसे इम्पोर्टेंट इसमें जैसा मैंडेटरी अब हो गया है डीएनए रिपोर्ट का। डीएनए रिपोर्ट में चूंकि पेंडेंसी ज्यादा है, पर पॉक्सो एक्ट के प्रकरणों में जैसा कि शासन स्तर से भी निर्देश जारी हुए हैं, इसको एक प्राथमिकता के तौर पे एफएसएल लेबोरेटरी इसमें प्राथमिकता के तौर पे इसको लेती है। यही अनुरोध हमने भी यहाँ डायरेक्टर एफएसएल जो सागर में है उनसे किया था।
India has over 400 fast-track courts, but as per NCRB, less than 10% of the cases are disposed within a year of an alleged sexual assault, which also shows on an average a rape case normally takes 2 to 3 years for reaching a conclusion. The timeline of these cases are nothing but astounding, but are any corners being cut?
The Madhya Pradesh government says no. They say to fast-track DNA report, the police got either saliva, blood or semen, which takes less time to evaluate in comparison to samples like bone or tooth.
In these cases which you're referring to, these samples have been of semen stains, they have been of saliva, there's been the blood, and out of this the net result is what the forensic scientists have given it, and honorable courts have appreciated it, and it has resulted into conviction against the accused in those cases.
हम लोगों ने फास्ट ट्रैक कोर्ट बनाने का काम किया. हम लोगों ने अलग से सारे इन्वेस्टिगेशन के लिए अधिकारी नियुक्त करने का काम किया और इसमें मुख्यमंत्री जी के स्पष्ट निर्देश थे कि कम से कम अवधि में न्यायालय में चालान प्रस्तुत होना चाहिए. तो सारा सिस्टम उस प्रक्रिया में लगा हुआ था और एफएसएल में भी गवर्नमेंट के निर्देश थे कि इसमें त्वरित रिपोर्ट हम लोगों को चाहिए है तत्काल.
But everyone is not convinced. Child rights activists say they are apprehensive.
The DNA test or whatever forensic report, it takes almost 15 days to come. Now, even if they're doing it as early as possible, but I don't believe that, the police must be doing it so properly. To collect the evidences of that child takes little time. So if they're saying that within 5 days they have done this, so I have certain apprehensions.
If any state needs to crack down, it's Madhya Pradesh, as the NCRB data for 2016 shows 4,882 rape complaints across the state. That's shocking, 13 rapes a day. If there is anything worse, it's that minors make up 50% of these horrifying rape numbers, 2,479, which means 6 children on average are raped a day. What hasn't been proved yet is if the quick handout of death penalty will bring the shocking numbers down. With Rakesh and Arvind in Bhopal, Anurag Dwari for NDTV.
Okay, there are so many questions about this and I really want to get to some of it with our experts. And joining us today, we have criminal lawyer Sherbir Panag. We also have Bharti Ali, who is of HUC. They deal with juvenile crimes and she's an expert in that. She also dealt closely with the Nirbhaya case. And we also have Neelam Krishnamurthy, who is, because she's been her case of her children in Opar tragedy has now extended for 30 years?
21 years.
21 years, and so she's quite a bit of a lawyer herself and she knows how long usual judicial timelines are. And to explain to us how Madhya Pradesh is doing this, we have Vibhanshu Joshi joining us from Bhopal. Now, I just want to point out to our viewers and to our experts over here the kind of comparison that we did to try and understand and gauge what a difference and how Madhya Pradesh has taken a leap. So, let's give you the timeline of one of the cases that has seen a death penalty in Madhya Pradesh. In that one, in the rape of a 3-year-old's case, you have the charges being framed in 3 days. You have the entire trial lasting 26 days. And on the 27th day, you have death sentence, right? Within a month, everything being done. Then you have another case of the rape of a 9-year-old in which you have investigation in 72 hours. You have the charge sheet being filed in 4 days. And to just give you context to this, the usual time that police have to file a charge sheet is 3 months, and most of them miss it. So the charge sheet being filed in 4 days, the DNA report was obtained in 10 days, the trial was completed in 46 days, and then you had the death sentence just after 46 days. Now, let me tell you about the most high-profile sexual crime that we've seen, which changed all our laws, the Nirbhaya case. Even that was very, very long compared to all of these cases. In the Nirbhaya case, you had December 16, 2012 is when it happened. It took 17 days, so it was very quick, but even there it took 17 days to file charge sheet. Then it took 32 days after the incident for the trial to start, and then 9 months later, 9 months after the incident, you had the verdict in the case. So that's what the timeline is. So Sherbir Panag, when you hear of this timeline that we are seeing in the last 9 cases of death sentences in Madhya Pradesh, does it look like, what do you think about it?
Sunetra, I think at the onset, rape is a heinous offense, and it's something that's brought a lot of shame to our country and to us as its citizens. There's going to be no one easy solution to stop such incidents from taking place, and it requires a complete major overhaul, not just from a legislative perspective, but also from the courts as well as from the investigating agencies. We do want, the need of the hour will be speedy justice, but also speedy justice where in trial due process is sacrosanct. In a legal system such as ours, which is an adversarial system, the presumption of innocence cannot become the presumption of guilt merely because of social, cultural, or factors or media trials for that matter. Now, I haven't read the case papers in these instances. There are likely to be apprehensions on due process, from a due process perspective, but some of these don't sound odd. 3 days for framing of charges seems to be very reasonable, and a court or investigating authorities that are providing more resources to conduct an investigation, brief the prosecution department in time and appear in court is definitely a departure. And I think we should, at some extent, from the timing perspective, this deserves to be, if I may say so, to some extent applauded, and it's a considerable departure from what we've seen in the past. This brings us to the second element about the aspect of the death penalty. When we consider the death penalty, we of course must not forget that the death penalty is the most harsh form of punishment as far as retributive justice goes. The Supreme Court has given fairly elaborate guidelines as to what must be followed in such cases, and it's not an automatic punishment. It doesn't mean that if every single accused who's convicted of raping a girl under the age of 12 years must receive the death penalty. So the contours of the Supreme Court's guidelines, as well as what's been laid down by law, need to be followed there, and I think that's a matter of test which will depend upon how the appellate courts view them if these matters are appealed. But I think the third element, Sunetra, is something we need to consider as to the method that the legislature chooses when they decide to provide such a harsh punishment, such as the death penalty. The acting Chief Justice of the Delhi High Court, Our Ladyship Geeta Mittal, in fact, asked the government, has there been a scientific assessment that's been done to determine whether the death penalty will actually serve deterrence? We have countries where the data isn't very promising, such as the United States. We also have countries closer to us, such as Pakistan and Afghanistan, where the data hasn't been that promising. So I think the moot point is, for a democratic constitutional country like ours, in the absence of scientific and empirical data, is our legislative process merely going to be reactive when we're going to consider issues as serious as the death penalty? Secondly, have we evaluated whether the death penalty is going to serve the deterrence that's necessary, or will it, like some experts have said? Okay, like some experts have said, that will rapists now go and kill the victims because the punishment for murder and rape is the same?
That's a whole different debate, and we have been doing that. But here, I just wanted to look at the possibility, and what you're saying is, if some of these timelines don't look outlandish to you, that they are possible, that the real question is, when are we going to see it in all other courts as well? When are we going to see these timelines or fast tracking in other courts as well? You wish that, don't you, Neelam Krishnamurthy?
Definitely I wish, after going through a prolonged trial for over a decade. See, I have been going to the courts for the last 21 years, and we've seen our case where the trial court took more than a decade to convict the accused. It took almost 10 years for a trial, just for a trial. And
those also children, being most people who were killed in Upahar were
23 children. And that also only after there were directions from the High Court to fast track the court. Otherwise, the trial would have taken probably 2 decades. And now here we have a case where the case has been decided in a very little time. Probably that's what we want.
Yes.
But in India, we've actually seen, and that's why you have all the trials, and in fact, all the discussions that you have on justice delayed. It is hardly even justice hurried, is justice buried. So here what I'm seeing, the trial has been conducted in a very short time. I just wonder how, because the trial itself has about 6 stages. Normally it's 7, because since it's a sessions trial, so we don't have a committal stage in that. We have first the charge sheet is filed, the copies are given. I'm speaking in a layman's language, so everybody understands. I'm not reading the sections.
Right.
So when the copies are provided to the accused, then the charges are framed. The accused has an opportunity to appeal against this order in the High Court if he wishes so, which can take about maybe 6 months, 1 year, maybe more. And then thereafter you have the stage where the prosecution witnesses are called for. You have a stage where the accused, questions are put to the accused under section 313. then the defense witnesses, and then the arguments. So all these stages take a lot of time.
And actually, one of the things you and Bharti Ali were mentioning, which I want to take to our BJP spokesperson, who's also a POSCO expert, by the way. So he's exactly the person we need from Madhya Pradesh to explain things to us. And what was that question, Bharti Ali, that you were asking, that how POSCO says that you have to take the testimony, have to speak to the victim in this case, and you have to take a month perhaps to. So explain that to our viewers.
Well, yes, the POXO Act says that the victim's testimony has to be recorded within 30 days from date of cognizance, and the trial is to be completed within a year from the date of cognizance.
It says a year.
It says a year, but now we have a new law that's been passed which reduces the period for completion of trial to 2 months. And not just that, it actually takes away the discretion from the courts. The word used is that trial shall be completed within 2 months. And we've got about 500 cases of children who are victims of sexual abuse under the POXO Act.
Across the country.
And this is Delhi. I'm
Right.
talking about Delhi, where Huck Center for Child Rights is providing legal and psychosocial support to 500 children who are victims under the POXO Act.
So what's the problem with such a quick timeline?
And the problem is there are several children who are not prepared, not ready to depose in court even in a month's time sometimes. Then there are children with disabilities who take longer.
Like we're seeing in Bihar.
Right, like, yes. And we are, and you know, Delhi is very fortunate. It has one of the best systems, I must say.
Yeah.
But there are states where there are no support persons given to children.
Yeah.
So we can just imagine the kind of testimonies.
So let's take that thing. Bimanshu Joshi, how did you manage that? Because if the court and the law also says that these children, and these are 3-year-olds, in one of the cases, the 3-year-old, the other case that we saw the deaths in a 9-year-old, how did you manage to get them to open up and give their testimony in such a short while?
Yes, Sunita ji, there is a momentum in the conviction in Madhya Pradesh. Of course, it goes to, with the constitution, as we have a good governance in the Madhya Pradesh, and the new ordinance has come out. ये जो नया ordinance आया है, देखिए, even when we have a POXO Act, Madhya Pradesh was working according to the POXO Act, like the other lady said, that under POXO Act 37, section 35, it is there that 30 days evidence is there, 1 year there should be a trial, this should be over. So in Madhya Pradesh it is going on. Now, as per the new ordinance, the trial is coming out in a very fast
I know.
manner.
How are you getting the children to depose so quickly?
Recently, the lady said that yes, in Madhya Pradesh we have child lines, we have one-stop center. Through one-stop center, the complainant come through there. And recently, the appeal court, I just read the judgment, yesterday judgment from the appeal court, that is the Jabalpur High Court. What the Jabalpur High Court said yesterday on the Shadol case.
Okay.
This court has the social responsibility to make the citizens of this country know that law cannot come to the rescue of such a person based on the humanity. This is on the capital punishment yesterday. And so the High Court uphold the judgment of the Session Court that there should be a capital punishment. So higher courts also, appeal courts also are coming.
I understand.
Very fastly as per the new ordinance came by the Modi government.
Sure, Mr.
Now
Joshi,
Madhya Pradesh is the
we
first
are all
state.
amazed by this.
Yes.
What we're trying to understand
Yes,
is that processes which have taken years, which we've seen take years, how is it being done in a month? Yeah, very quickly. Yeah.
So I want to ask, actually, please tell me, POXO says that the child welfare committees are supposed to assign a support person to every case. So I need to know how many support persons have been assigned till date in all the POXO cases in Madhya Pradesh. None of the states are assigning support persons except Delhi. And Delhi too has its limitations because they are having to rely on NGOs for it.
Okay, I have a question. Sherbir Panag, one of the things that... Sir, Mr. Joshi, one second.
As the rape cases, we need the women police.
Yes, sir. Yes, sir. 1 second. Sherbir Panag, one of the things that's a real mystery to me is, as someone who's covered crime for some time, and it continues to be a huge... you know, it's something that I'm quite obsessed with. One of the things that we see, which takes a long time, whether it's the Arushi case or anything else, is the DNA evidence which is collected, right? In how is it, and those are, you have 3 or 4 CFSL labs in the country and everything is sent there, and those are the ones which get held up for months, if not years. How is it that they manage to get DNA evidence and corroborate that within 10 days? How, can you tell me from a criminal lawyer point of view?
See, Sunitra, I think the moot point you I think we have consensus on this aspect, that we as a country, to address the issues that we have, the entire criminal justice system needs to have more resources. We need more resources at the police level. We need more courts. It's not the number of fast track courts aren't going to be enough. The number of CFSL labs aren't going to be enough. Having said that, this would definitely bring about some apprehension about whether things were rushed, but that only the trial court record will be able to tell us. My point being that in cases where the number of witnesses are lesser, cases where the evidence framework is smaller, do not need to take as long as we can't compare apples to oranges between an Uphaar and a case involving a single victim with 18 witnesses versus Uphaar where the numbers were far greater.
You're and right, that's a good point.
The evidence pool was far greater. So I think that's the first point I want to make. It goes without saying we need more resources. Having said that, if a state government does decide to put more resources in, I honestly find no reason why these timelines cannot be adhered to. And third, but I think we need to come back more, Sunitra, a quick point I want to make. We need to come back more to address some of the other issues of this law. For example, it doesn't address boys. If you look at the 2007 report of the Ministry of Women and Children, where out of the sample that was surveyed, which is nowhere close to what the numbers are likely to be, the majority of children who suffered sexual abuse were boys. And this ordinance it hits out, and now the bill looks at girls under the age of 12 years, but doesn't address the issue of boys. So I think we also need to look at some of the elements of where the law hasn't met up. And having said that, due process is sacrosanct.
Due process is sacrosanct. So any other concern about the due process?
Well, as far as due process is concerned, I think, over the years, the rape law evolved to take into consideration the needs of the victims, to become more victim sensitive.
Yes.
But we've just done a reversal by making it mandatory.
Isn't this, but the Madhya Pradesh government or the government would argue that we are being victim sensitive because we're giving you justice very quickly.
But that's exactly where we are fooling people. The ground realities are speaking much more. The ground reality is most abusers are known to children. They are known people. A lot of incest cases are happening.
So you're saying the death penalty is a problem?
There are children who will not even report against their fathers. And we've already started getting calls from parents saying that, is he going to get death?
Neelam Krishnamurthy, in the final thing, you had some concern about the felicitation. Do you want to bring that up?
Yes, definitely, because what I've read, the Chief Minister of Madhya Pradesh is felicitating the policemen and the prosecutors. So probably they're being encouraged to get the convictions done at the earliest, and by ensuring that the due process of law is not observed. What my worry is that tomorrow, if you're compromising, they will get the benefit and get acquittal in the High Court at the time of the appeal. That's why I said justice hurried will be buried. In case if a proper process is not followed, they must ensure that proper evidence is led, so it doesn't get the benefit to go and tell the High Court, I did not get enough time. I have seen cases in Delhi High Court where cases are sent back that you haven't given them enough time and retrial has started again. And we do not want that to happen.
I know, but Mr. Joshi just told us that the case had been upheld by one of the High Courts.
That's just one. Let's see about the others.
So are you going to, Mr. Joshi, in the final thing, is the MP government now setting up fast-track courts beyond sexual crimes as well for all kinds of cases?
As the POCSO Act, with reference to the POCSO Act, जो लड़कों के बारे में कहा गया, उसके बारे में भारत की जो मेनका गांधी जी हैं, मंत्री हैं, उन्होंने POCSO Act में अमेंडमेंट के लिए भी 12 साल वाले लड़कों के लिए भी बात कही है. तो वो मेनका गांधी जी उस बारे में काम कर रही हैं, वो बात थी. और जैसा कि आपने बताया कि हाई कोर्ट भी बहुत सीरियस है. देखिए, ये सीसीटीवी जो है, दैट इज ऑल्सो वर्किंग वेरी हाईली इन मध्य प्रदेश. सीसीटीवी, क्योंकि जो सुचिता जी ऐसा होता है जो रेप केसेस होते हैं वहाँ एविडेंसेस आमतौर पर नहीं मिलते हैं, कोई विटनेस होता नहीं है वहां पर। तो ऐसे मूवमेंट में सीसीटीवी ने ये जितने केसेस मध्य प्रदेश में है उसमें जो सीरियस एविडेंसेस हैं उसमें सीसीटीवी ने भी बहुत महत्वपूर्ण भूमिका बनाई है। तो ये जो सीसीटीवी का जाल है वो जितने भी आप जजमेंट्स देखेंगे उसमें सीसीटीवी डीएनए से तो उसको कंफर्म किया ही गया है। तो मुझे लगता है कि और मध्य प्रदेश के मुख्यमंत्री जी ने जब मंदसौर में घटना हुई थी उसके बाद मध्य प्रदेश के हाई कोर्ट के चीफ जस्टिस को भी चिट्ठी की थी और अपील को भी पास करने की बात करी थी।
विभांशु जोशी, we're totally out of time, so I want to thank you, Neelam Krishnamurthy,
लगता है चूंकि
Bharti Ali and Sheni Kalam. We're totally out of time, sir. I just want to point out that this is just not in Madhya Pradesh. We've also had such fast-track courts giving quick justice in other sexual crimes in Rajasthan and other parts of the country like Punjab as well. The only question is, will this fast-track justice extend to other parts of the country and also in other types of cases as well? And what a lot of the people like activists hope is that justice should really be served and there should be no shortcuts to justice. So yes, to fast track a lot of these forensic laboratories, but not to have shortcuts for justice as well. Thanks to all my guests. Thanks for watching. Goodbye.